Welcome to Q&A practice. Let's start out with the court. Ready? Here we go. We are in chambers outside the presence of the jury. The defendant's representative, Mr. Wallace, is here. People's representative, Mr. Allen, is here. Mr. Allen, you said there was something that needed to be brought up outside the presence of the jury and witnesses. Yes, two things. One, very minute. I wanted the court to know the situation. It's not a real situation. I talked to defense counsel about it. We're going back into court, and defendant was before us. I'm always very respectful. I'm friendly with the defendants always, and the security found a cuff key that Mr. Landon had on his keychain, and so he asked me if I would hold on to it and give it to the defense counsel to give to him after we're done with court, and so I wanted the court to know that's what I did. Okay, it's not a big deal. I didn't feel exactly kosher about the whole thing. I just wanted, all right, to make sure it was known what happened. All right, that's not an issue, I believe, that has any business in front of the jury. I appreciate you bringing that to the court's attention. What is the other issue? The other issue is this. I don't know how, but for some reason, Beth Jones has at one point talked to a civil attorney about the situation. Bill Randolph, yes, that's who's seated in the audience, correct? He was not retained, nor has he been retained yet. Okay, he has only discussed what her options are. Okay, I don't know if defense counsel intends to go into that, but I think under 352 that's not proper or relevant. If I could just finish, just because of the mere questioning or inquiring what her rights are under the law, I know defense counsel will say it goes to motive why she may say something. He has not been retained, not filed suit, nothing of the sorts. All right, can I respond? Yes. In June 2010, I tried to get an interview with Beth Jones. We were referred to Mr. Randolph, whose office represented to my investigator that he was in fact representing her. That would be no statement except through him. Okay, we did try to get it, but we didn't get it. We called back today to confirm whether or not he was still representing her. He shows up here. I just asked him, are you representing her? He told me yes, so I disagree. It absolutely goes. I guess I get to discuss the fact that I tried to get an interview with her, that she did not cooperate with my request for an interview, and the fact that she has a big-time civil attorney known for suing the Landview Police Department actually goes to motive, bias. Hold on a second. I'm sorry. Continue. Go ahead. Absolutely goes to motive is where you left off. Yeah, motive, bias, prejudice. All right. One, has a lawsuit been filed? Do you know that? No, I do not know that. The answer is no. I don't know of any that's been filed. Okay. Now, did you try to talk to her? Absolutely fair game. Did she refuse to talk to you? Absolutely fair game. Were you referred to an attorney's office? Absolutely fair game. Mr. Randolph and his reputation as a big-time civil attorney. No, we're not going there unless you are privileged to any of the communications between her and him. In other words, unless you know of what the subject matter of the communications are specifically and can tell me whether there's impeaching statements. And then we're not going to go into that. Besides, I'd have to hold another hearing about attorney-client privilege. I'm not saying that it couldn't potentially be pierced. I don't know. What I'm saying is, unless you have a legitimate basis that you can provide to me as an offer of proof, then no. But the fact that she refused to talk to you, the fact that she retained counsel, the fact that those questions were directed to that retained attorney, sure. That's all we would want. We're not talking about Mr. Randolph being a high-profile civil attorney who sues the Landview Police Department or any law enforcement agencies. Fair enough. But I'm just telling you, if there was a suit filed, fair game. I think realistically he wouldn't file a suit until this matter comes to conclusion. I figured whether he was retained or not, this is the type of case. I was not surprised to see Mr. Randolph Is it Randolph? Sorry, I said Randolph. That's horrible. It's Bill Randolph. I was not surprised to see him out there, if for no other reason, even if he did not have an oar in the water, so to speak, might be interested in seeing how this case plays out. Judge, I just want to make clear, I guess we can say this is almost like a 402. But that it would be improper for defense counsel to ask why she retained a counsel as well, or why she looked into it, because there is no suit filed. Hang on, let me think about it for just a second, both of you. Why wouldn't you speak to me? I would allow him to ask the question why, but he has to live with the answer, whatever it happens to be. If that answer is because my attorney told me not to, or oh, why, to find out what my rights were, whatever she happens to say, both sides are going to live with. We are not going to go into an evaluation of of the merits of a potential civil suit. I don't think the jury would be at all surprised by it. Whatever the answer is, both sides live with. Decide whether or not you want to ask that question. I just need the very basics. I just want to be clear that if that question is posed, I believe that opens the door to prior consistent statements, because it goes toward her bias. Prior consistent statements to whom? Everyone that she discussed with prior. Hold on, refusing to answer the question. We'll cross the bridge when we come to it. I'm not seeing it completely, but I asked to speak with you. You told me no. You directed me to your attorney. You directed me to an attorney. Next question would be why you'd seek an attorney. No. You don't think that? No, I do not. I think that is a refusal to speak, which shows a bias towards his side. That is not. I'm more than happy to review this issue once we've developed a record, Your Honor. But I'm not going to go ahead. I'm sorry to interrupt. Go ahead. If she states the comment, which defense counsel knows she's going to say, why did you talk to an attorney to see what my rights were civilly? That's going towards motive. Okay, I do not believe that will give you a basis for prior consistent statements, but once the record is developed, you're free to readdress this issue, and I will consider it in light of the entire record that is developed at the time. Understand this, when we talk about hearsay, especially hearsay, every time a person says something new on the stand, there is a potential for a reevaluation of every ruling in terms of hearsay. Both sides are aware of that. You both have been around long enough to know that many rulings that you get by way of inadmissible or admissible hearsay can change as the trial develops. So that's all I have to say about that at this time. All right, I'm not going to rule absolutely that asking the question why and whatever the answer happens to be necessarily opens the door to prior consistent statements. If and when it happens, you can ask me to review it. You can explain why you believe that you now get prior consistent statements, and I will rule appropriately at the time. 2. I can envision answers that she would give that would open the door, answers that she would give that would not. Just formality purposes, when we believe perhaps a door has been opened or a ruling should be changed, what do you want us to do? Go sidebar, or wait until a break if one's coming up and ask to address the court, then okay. Don't barge through the door. Won't happen. Okay, clear enough? Crystal, all right, I will reverse myself if shown it's appropriate. It works both ways though. Okay, know that the rules of evidence. I'm a guy with a black and white striped shirt. I'm the ref. I call it based on whether the predicate showings have been made or not at the time. Was that okay? What I did with everything was fine with what I did, right? There was nothing wrong in terms of asking for a break. No, about I don't think he should have the key. I think it may be a violation for him, a violation of law for him to have a cuff key. I'm not certain. Right, let's see what else we have. For a bit more Q&A practice. We will start with the plaintiff attorney. Ready? Here we go. There is some 1109 evidence that yes, I don't believe it is, but that's another issue. Okay, another, but not necessarily an important issue, I would assume. No, it's an important issue. I was going to bring that up in one of my motions in limine. So Anne says several months ago the victim said she was afraid of defendant who had been abusive towards her. Yes, you say there was a divorce. You use the term pending. I don't know what pending means. Was there an actual filing in a divorce action? Yes. And a date of filing? Unfortunately, I don't have that handy. I believe it was in March or April of 2013. Madam Judicial Assistant is assisting us. She may have that information. I don't know from the family law court. It was filed in this county, I assume. Yes, my understanding it was filed sometime in January and it was to become final on the 10th of June. Well, then it was filed January 10th, probably. So filed in, we will just say this is the anniversary perhaps of the filing date, January 10th, 2014, 4 years ago, would have been the approximate date. So is that the only statement that you have from Anne? No. So that's 1. 2. In the report, it quotes Anne as saying, I assume all of these statements are reports from a reported date after the death and subsequent and part of the investigation. Yes. Okay, so the second statement by Anne to the police, right, is that Sue, the victim, told Anne Ryan via email that Sue was going to move to Portland and live with her daughter, Sarah Richards. It doesn't precisely say what date that was, but based on the way the report is structured, it appears to be during the same time as the statements that the victim was afraid of the defendant. I mean, that one seems to be a lot less problematic as far as the use of it. People get divorced, Mr. Allen. They usually make some kind of plans of where they are going to go. Correct, but there was no, in fact, in the discovery just a few days later, one of the witnesses says, yeah, I'm planning on moving when the divorce is final, but it may not be for a year because it's going to take us a while to get this place cleaned up and ready to sell. I mean, if that would also be relevant if they are saying something like, that she was planning on just taking off the day after. Sure, I agree with you, but that's a little different than whether it's admissible. I mean, if we are going to talk about what her statements may have been. And we will stop there. That will conclude our Q&A practice.